Happy evening to all of you. Welcome to today's meeting. Thank you all for sparing your marvelous Monday evening. We have with us now our today's resource person, Ms. Vanitha Patnaik, and SIRC Secretary, CA Ayampalayam Venkadeshan Arun sir. Welcome to both of you and to our delegates. We will start today's proceedings with the invocation of ICAI motto song as a mark of respect to our mother institute, ICAI. Technical team, please play ICAI motto song. There may be some technical glitches, it seems. May I now request SIRC Secretary Ayampalayam Venkadeshan Arun sir to formally welcome the delegates present today.
Good evening all. On behalf of SIRC, I welcome to today's speaker, Ms. Vanitha Patnaik, for the session. So very recent days, in every newspaper, we heard the word the Competition Commission relating to Google. That too, every NCLT upheld. So many decisions relating to Competition Commission is pronounced very recently. So that the SIRC thought that the act like Competition Commission, we should know about the preamble and other things about the Competition Commission, so that the SIRC organizing the programs, the act relating to Competition Act. I think our today's speaker, the Vanitha Patnaik, is well versed with the Competition Act. I welcome you all once again for the program, the Competition Commission Act's program.
Thank you, Arun sir, for your welcome address. Let me introduce Ms. Vanitha Patnaik. Ms. Vanitha Patnaik, Assistant Professor Law, National University of Juridical Sciences, West Bengal, has been in teaching since 2003. Her subject specialization is in corporate insolvency, insurance, mergers and acquisitions, international investment laws, international commercial instruments, laws of banking. She was the first Indian student to study at the Summer Academy at the International Tribunal for the Law of the Sea, for Uses and Protection of the Sea, Legal, Economic and Natural Science Perspectives, Hamburg, Germany, with full scholarship. She did her Master of Law and Business Management from Bucharest Law School, for which she was granted full academic scholarship. She also had a research scholarship from Max Planck, Hamburg, University of Dundee, Scotland, and she has delivered lectures both in India and abroad. Amongst some of the institutions where she has lectured are Hamburg University, Hamburg. She has experience as consultant in INSOL International. She has been a contributor to many industrial publications and academic publications on a range of subjects like insurance to arbitration. She heads the Center for Financial Laws as well as the Mediation Clinic at the National University of Juridical Sciences, West Bengal. She has extensive experience in corporate training in areas like RTI, POS, contract drafting, economic offenses, employment laws, cyber laws, mediation and conciliation. She has been responsible for designing courses and training programs for senior executives for the Durgapur Power Plant, West Bengal Power Development Corporation, HPCL, EOW of the West Bengal Police, Swami Vivekananda State Policy Academy, etc. She has been an invitee as a resource person for training programs at IIMC, Symbiosis Hyderabad, KIT, SOL, XLRI, NIFT, Pondicherry University, amongst others. With this brief, I present before you Ms. Vanitha Patnaik to handle today's section on Competition Act. Over to you, madam.
Thank you, sir. Thank you very much for such a kind, generous introduction. So today's topic is on competition law, and if today's class is happening, if I'm candid, the thanks should go to Shivani ma'am, because of a mix-up, I had essentially put today's session on the 21st in my calendar, In fact, in the morning when she called, I confidently told her, yeah, I do remember it's on 21st at 5 p.m. And that is when she drew my attention. No, it is not 21st, it is today. So with my apologies with that and my thanks to Shivani ma'am, I'll start the session today. And the reason why I'm apologizing is the number of cases that I could have compiled. Usually this today's session does not have that many cases, but what it does have is it does have an analysis of the various provisions. So I did not have the time to put in the cases. So in case the session ends a little bit ahead, I'm sure, I hope all of you will understand. So Competition Act, as we know it, as you said, rightly said, that it has been in use for very many reasons, many of them good reasons and many of them not so good reasons. So to understand the essence of this act, we need to look back, because any subject, any topic to understand, you will have to look into the past, the history, and then see where it is standing today. So given the economic development of India, wherein we first, right from post-independence, we had the industrial era. So through the 55s, what we had was mostly a licensing Raj. So the Hazari Committee, which came about in 1955, what it did reveal to all of us was the disproportionate and unbalanced growth that the economy was having because of the licensing procedures. This was later on followed by around 10 years hence, around 64, by the Mahalanobis committee report. This report was specifically on the distribution and the different levels of income. Is my screen visible to all of you? And primarily, this Mahalanobis committee report looked into your concentration of economic power in a few hands. Ironically, we find the same thing happening even today. We find this concentration of economic power again going back into a few hands, as opposed to what we had all this while, where it was dispersed among the majority of the population. Now, as an outcome of these two reports, what we had was the MRTP, that is your Monopolies Restrictive Trade Practices Act. This came about in 69. The whole aim of this act was to reduce the concentration of economic power. How did it do it? It tried to put restraints on trade. It was restrictive by its very nature. So as it would have, by essentially having restrictions, it became too draconian. It was stunting the growth of the economy. So by 2000, we had the Competition Act. But post Competition Act, we also had many reports which have developed the Competition Act, and from time to time we come out with CCI does come out with its guidance notes, with its regulations, which help moderate the economy. If we have a look at the preamble, what does it say? For the preamble, it very clearly says that this is a commission that has been set up with an aim to have a control over the any action that has an adverse effect on competition. Now, how do we understand competition? Competition we understand by having, if there are any at given point of time, if there are choices available to the consumer or not. So one more perspective of looking into into the Competition Act is to see whether it is a consumer friendly market or not. So as long as the presence of players are there and the presence of players makes it consumer friendly, then it is seen to be a neutral market. So whenever there is a player that has an adverse impact to such an extent that it has an impact on the competition, on the choices of the common man, that is where it becomes anti-competitive behavior. So this commission was set up primarily to prevent any practices that would have such an adverse impact. It was set up to promote and sustain competition in the market, to protect the interest of consumers, and to ensure freedom of trade carried on by the participants in the market. So that was the whole idea with which this committee was set up, or this commission was set up. And to understand this, how it carries out, it has been given very many weapons or or instruments, as you might want to call it. And one of the most notorious sections is your section 6, of course. But before we come to section 6, I'll just go through your 3 to 5. So if we look into the Competition Act, essentially we find in any given discussion these 3 sections: anti-competitive agreements, abuse of dominance, and your mergers and acquisitions, that is your section 5 onwards. So these are the 3 sections that is mostly in vogue. Now let's come to anti-competitive. In anti-competitive, what do we understand by anti-competitive? We understand it as collusive behavior. Whenever you have among the organizations, among the businesses which run parallel in the same market, any agreement that essentially does not again provide the freedom of choice to the consumer, that is called your anti-competitive agreement. So if I have to buy an apple for 10 rupees throughout the market, so it leaves me a little choice about the pricing, because it says that everybody is selling it at rupees 10. So if this was driven by the market demand, then it is a okay thing. But if it is driven by a collusive behavior in the market, as it has happened and has been caught time and again in your cement business, in your tire business, and others as well, the Competition Commission has actively caught on to them and has restrained them from practicing such behaviors. So these are called your anti-competitive agreements. There are 2 types of anti-competitive agreements. First is your horizontal, and this next is your vertical. What is a horizontal? Where it in 2 unconnected businesses would come into a agreement or an arrangement for price fixing, or this is what we call them as your, where you have a collusive behavior, and the entire market, it gets controlled by 1 or 2 or more players. So it is almost like cartelization happening. So this is manufacturer versus manufacturer. Vertical, the good example would be manufacturer versus retailer, where you have absolute price fixing in between the manufacturer and the retailers. Not necessarily they are a bad thing. Not always they are anti-competitive. Many a times it is these agreements that help in expanding the scale and the scope of business as well. So it is not like they discourage. The only element or the test that is seen is whether they are consumer friendly or not, whether such an agreement would be having an adverse effect on the consumer on the ground or not. If it does not have, then by all means these agreements are permitted to be conducted. You cannot have an increase in capacity, scale and scope without having a horizontal agreement or without having a vertical agreement. So there is nothing wrong in having it as long as they follow the diktats of the business. It's only when they start colluding with each other for making unfair profits at the cost of your consumers' behavior or choice, that is where the law steps in, and that is where the law says that this is having an adverse effect. Till that point of time, it is all permitted. Now, what is an agreement? We have just now discussed your horizontal and your vertical. So what essentially is an agreement? So Competition Act, or even otherwise, what we understand is an agreement is nothing but an arrangement. It is an understanding. It is an action in concert. So it could be that there is an unspoken collusive behavior that too would be recognized. That is called persons acting in concert with each other. There could be an implicit understanding about the price fixing or about the behavior or the pattern of running of the business, or there could be a express arrangement. So any of these things, said, unsaid, expressed, not so expressed, would fall into the concept of an agreement. And again, just to put it into context, a horizontal agreement would be an agreement between competitors, and this is of a serious concern primarily because it involves elements of elimination and creation of monopolies or oligopolies, where the distinction between, you know, who is coming and who is going out is absolutely controlled by one or two players in the market. So if you see the slide there, all horizontal agreements are not bad by themselves. They have been differentiated from cartels. So cartelization is where you have, you know, these unspoken agreements with regard to the pricing, with regard to the functioning, with regard to the sale, with regard to the storage. Whereas any horizontal agreements relating to research, development, production, commercialization, information exchange, which might actually lead to a betterment of business functioning, is encouraged. So while they may be by competitors or in between competitors, anything that does not impinge upon the consumer's interest or choice is definitely permissible under the Competition Act. Similarly, when we speak about vertical agreements, this is essentially a vertical integration of a business structure. And because of that, it provides a higher or a quick turnaround for a business to conduct if it has got an entire supply chain arrangement already in place. And this is the reason why vertical agreements are seen as the lesser evil in between your horizontal and vertical agreements. Again, they are not entirely correct. They're not entirely wrong. What is seen is about their impact. Now let's come to what the Act says. So far we have been dealing with sections 3 and 4. And now we come to the regulation of mergers and acquisitions. So mergers and acquisitions are nothing but a combination of these 3 and 4 in between the horizontal and the vertical. So when we have such, these are dealt under your sections 5 and 6. And your Competition Act is the principal legislation that deals with it, and your 5 and 6 deals with your mergers and acquisitions. Now, what happens when you have a merger? What happens when you have a merger is you have a sudden expansion of one party's presence in the market, because of which the Competition Commission says, I need to be informed if you are taking over one business over the other. So these are called triggering events. So any form of merger or acquisition or dealing which exceeds certain threshold limits and are not exempted have to be notified. That means information has to go to the Competition Commission and approval has to be obtained before completing the transaction. No transaction can be completed without having a clearance or approval from the Competition Commission. Just keeping that on hold, I'll just come to acquisitions and mergers one by one. So acquisitions is defined under the section 2A. And it very clearly says, very simply it says, directly or indirectly, acquiring or agreeing to acquire what? Shares, voting rights, assets, control over management, control over assets of any enterprise would mean acquisition. So business houses may combine their energies and synergies either by going through an acquisition or by going through a merger or simply by setting up a joint venture agreements. Each one of these would fall under your definition of your M&A, that is your section 5 and 6. And whenever there is a purchase of shares, there is a purchase of assets. Essentially, we call them acquisitions more than mergers. So what are mergers? Mergers are when such assets and liabilities get transferred absolutely and the first entity has a natural closure. So merger or amalgamation are essentially when two or more companies become one entity. Similarly, the opposite of that is your demerger. So whenever there are assets and liabilities of an entity that gets transferred with the essence of the first entity losing, we understand it to be a merger. So what's a combination? So combination is the same thing. So it is your merger acquisition, which is called a combination, or an amalgamation is called a combination, wherein you have two or more existing companies which come together to form a new company. They do have a tendency of losing their current identity. They have a tendency of taking on a new form, and they take on the new business format as well. So whenever assets turnover thresholds under section 5 are crossing, they are called combinations. So whenever you have a merger, whenever you have an acquisition and a particular threshold is crossed, I'll be coming to the thresholds in a minute, are crossed, by default your section 5 gets triggered. So the moment section 5 gets triggered, your competition commission needs to be informed about it. But point is, who will inform? Will it be the proposer who will inform, or will it be the company that is getting acquired who will inform? Whose responsibility is that? So this is where the debate happened quite recently, and I'll come to that case in a short while. So for now, let's deal with your section 5. So section 5 says when more or one enterprise gets amalgamated and exceeds, this exceeding of threshold is understood as assets and turnover of parties. So the target enterprise and the acquiring enterprise, when it is merging, that is when the threshold is seen. And for this reason, the Competition Commission has put in a few tests of, if we can call them, wherein it identifies what this particular threshold is. So when we speak about threshold, we are essentially talking about value of assets. We are talking about turnover of the parties. And if you're talking about a combined turnover, or we're talking about the ultimate turnover, depends upon what geographical limits are we talking about. So acquisition, as has been defined under the Competition Act, it says that whenever there is any agreement in between the parties to take control of the shares or the voting rights or control of the management or of the assets. Now, once that has been done, then what happens? Once that has been done, your company will have to be tested on where it is located. So these thresholds that we talk about are essentially valuation of the assets, are valuation of the turnover of the parties, that is at the enterprise level. So if you see, there are two levels it is seen, at enterprise level and as well at a group level. So when we see at the enterprise level, the threshold should be on the value of assets and turnover. Same thing would apply even to the group level, but with the group level, whether it is entirely domestic or whether it has one leg in India and the other legs on trans-border, is something that needs to be kept into mind. So whenever Competition Commission looks into the threshold, it also looks into the geographical limits for the same. And over a period of time, the Competition Commission has been keeping on reviewing its thresholds from time to time, because when the Act was enacted in 2002, the thresholds that were prescribed then, it has undergone quite a bit of change. And in fact, your section 20 subclause 3 provides for a biannual review of these thresholds by the central government. So many a times central government also gives notifications. So when we look into Competition Act, we cannot simply look into the notifications by the CCI, but also by the notifications from the central government that needs to be kept in mind. Now let's come to the filing of notice. Who will file a notice? I'll deal with it in a bit, but for now the thresholds, let's have a look. So we are looking at two levels, the enterprise level and the group level. And then you have where it is purely domestic, that is India based, and where it is international but has a domestic leg. It's only if it has a domestic leg will your CCI have any jurisdiction, not otherwise. So essentially, when we talk about the enterprise level in India, it can be anything less than 2000 crore. That is the assets, or a turnover of 6,000 crore, then the threshold will be hit. Similarly, if it has just a leg, then either the total asset will be 1 billion US dollars or 1,000 crore in India's leg. Similarly, if it is turnover, then 3 billion US dollar with at least 3,000 crore on the India's leg. Next, when we look at group level, this is where it gets interesting. What it says is, if it is a group level threshold for filing of notice, what they require is they require less than 8,000 crore of assets if it is a purely domestic company. And if it is at a turnover level, then it has to be a minimum of 24,000 crore. So this is the distinction, or this is the thresholds that they have kept with CCI has kept with regard to enterprise level and at a group level company. Now let's come to enterprise level. So in an acquisition, whenever you are having assets and turnover, both the acquisition, the acquirer and the target are considered with regard to the assets and turnover. In case of a merger or an amalgamation, the assets and turnover of the enterprise remaining after the merger is seen, or the once it has been amalgamated post creation, how much of it is there, that is what it's seen. So the combined value of the assets and or the turnover of the merged or amalgamated entity is seen. So in case of an acquisition, it is just that what is the ultimate thing. In case of a merger, what happens post merger. In case of an amalgamation, what is the total merger. Okay, before I go to intra-group sales, when we speak about control by over an enterprise by a person, in such a situation, we are looking into when such a person has direct or indirect control. In such a situation, these assets or turnover have been with the enterprise over which the acquirer already has a direct or indirect control. So where it is just a person taking over in such a situation, this is what is seen, that the enterprise over which the acquirer already has a direct or indirect control is considered. So again, it's the same assets and turnover, but here it is seen along with the indirect control too. Now let's come to your intra-group sales. What is an intra-group sale? This is the exemption. So if you see here in this slide, I had explained to you about the filing of notice, when a notice has to go. Now let's say, for example, at an enterprise level, there is 2,000 crore, but sometimes, or rather let me do the group level, it will be much easier. So with the group level, it is 8,000 crore. So sometimes there are intra-group sales as well that needs to be exempted. So this is your intra-group sales. So this has to be excluded from the total turnover, otherwise it will be accounted twice. So to make life simpler, what your section 6 says is, it says that you have to exclude such intra-group sales. I'll just dedicate a few minutes to this and before I move on to the next one. So intra-group sales are typically excluded for computing the threshold limit. This is the basic thing that has to be kept in mind. So your section 5 here, it has to be less than 8,000 crore. This would be computed keeping in mind this, that if it's a group company, in such a situation, any intra-group sale will have to be excluded. And how do you identify the intra-group? You identify the intra-group purely by its location. Both the location of the parties of the intra-group and the scope of acquisition needs to be factored in for your section 5 and your de minimis exemption. So which is why I kept on referring to the India leg. So the location of the parties is extremely important with regard to understanding the exemption purpose. So these are the two tests that is prescribed, that is the parties test and the group test. What is the parties test? Parties test is where each of the parties will have a combined asset exceeding 20 billion or a combined domestic turnover exceeding 60 billion or a combined worldwide assets exceeding 10 billion. Similarly, in the group test, what they see is excluding the seller, these are the thresholds that are prescribed. And these thresholds are revised from time to time. And every time they publish a new set of thresholds, primarily to ensure that they are kept on top. So these are the two threshold tests that CCI prescribes and follows to identify parties who might be in violation or not be in violation of its Section 6 notifications. So parties test, again, very simply, when two or more companies within a group are acquired, only the value of sales between them can be excluded. Similarly, for the location test, what you have, the worldwide turnover location test becomes entirely irrelevant, primarily because you are looking into turnover in India. So for determination of turnover in India, the relationship test between the revenue and the in India is a big factor with regard to exclusion, particularly with the intra-group. So if after excluding the intra-group sales, that is when it is seen whether the threshold is triggered or not. After excluding this, if the threshold is not triggered, then they are exempt from moving on. So your it is to be seen the value of the assets, the turnover of the immediate parties, including the subsidiaries, are to be taken into account. Similarly, in the group test is the same thing, but ultimate parent or the holding company or the acquiring company entity surviving a merger should be identified. So on identification, its consolidated value of assets and turnover must be taken into account. So this is what is the most important part with regard to the triggering of the thresholds. Now, the notification with regard to these thresholds are always given by CCI. Notification to CCI is absolutely mandatory until unless there are exemptions available. In an acquisition, it is the acquirer who has to file the notification. Similarly, in a merger or an amalgamation, it is the joint responsibility of all the parties. I'll request all of you to hold this thought in mind for a bit. And this notification is generally made in your Form 1 and Form 2. So Form 1 is called the short form and the Form 2 is called the long form. And long form is typically used when the combined market share of the parties is 15% in any horizontal market and or 25% in any vertical market. So now you understand why I was explaining the horizontal and the vertical agreements. So this notification of thresholds, trigger of thresholds, is relevant directly to the Section 3 of the Competition Act. Now, these are the basic filing fees. Again, this gets revised from time to time. Once the notification has been given, the CCI, the transactions which are subject to review by CCI should be suspended until clearance is obtained. So if CCI is silent, which means there is a clearance given. And sometimes this review of 210 calendar days is inclusive of the information that CCI seeks. So whenever CCI looks into or is asking for any remedies or any corrections, then in such a situation, there comes in a period of additional 60 days, which is called the clock stop period, which essentially means the 210-day period stops at that point of time. So it's not inclusive of the time taken by CCA and the transacting parties to negotiate any remedies for which another factored 60 days is provided. So 210 plus 60 days is provided for the entire process. Now this investigation, when it is done by CCI, what happens? The part 1, the CCI issues a prima facie opinion whether the transaction is likely to cause appreciable adverse effect within the 30 days of its notification. What is appreciable adverse effect? Your double AEC is essentially where the CCI will look into whether such a amalgamation, combination, merger will have a dominant or will provide a dominant position which may be subject to abuse by this particular player. Or if it finds any one transaction wherein it thinks that, okay, this transaction will be having an impact of double AEC, only then it will put in an objection. Otherwise, it will simply approve the transaction and it will carry on with the business as usual. If it finds that it has double AEC, then it will put in a review. Once it puts in a review, it will require the parties to do fresh filing, and fresh resetting of the review clock will automatically follow. So this is your phase 2. Whenever the CCI has opined that double AEC, that is your appreciable adverse effect, has commenced, then it will extend the review period and call for an in-depth investigation. Post-investigation, CCI will either approve, disapprove, or propose modification. So majority of the disputes come in here in this part. So many a times it has so happened that CCI would put in an objection, and now that Compat has been taken over by NCLAT, then it's seen that it overturn its order and then put on its own judgment. So this investigative power of CCI is very strong, and it primarily looks into whether the market is protected or not so much protected. And because of this investigative power, what CCI looks into is it tries to see whether there is a dominant position that gets revealed in this investigation. So whenever you are having a dominant position, you are seen as an enterprise which has the strength to operate independently of the competitive forces, that it has a direct impact on the competition, or it has a direct impact on the consumers or the relevant market in its favor. And this was the test which Reliance Jio had to respond to, and it could prove that it is, while it does have a dominant position, it does not have a position wherein it can be independent of the competitive forces. So that is where the CCI gave out the judgment, the order, saying that, well, since there are other two major players in the market, it cannot be called a dominant player. While it is a major player, it is not called a dominant player. So the Competition Act essentially looks into operating of players or in the market wherein they would be not in a position, or would not be placed in a position where they would be to abuse the position of dominance, the dominance in the market. So the market share test is one of such tests. So what is a market share test? A market share test is where the act or regulations or any other laws which would help identify the market share of any particular player. Very quickly, here I just diverge a bit and say that whenever you have any other regulations in the market, like for example, TRAI had to step in with regard to when it was dealing with the market share of the cellular services, And similarly, you would have other regulators stepping in. It doesn't mean that's a clash. It just means that both your Competition Act and that regulation, they just deal with the independent areas and not, there are no overlapping areas. A licensing given by TRAI would be very different from the assessment of valuation done by Competition Commission with regard to whether the market share because of this licensing is dominant or not. So whenever you have more than one regulation stepping in, both have to be read together, but at the same time independent of each other and not together. Now this investigation on your abuse of dominance, how do you see that? So you can identify this abuse of dominance by essentially predatory pricing, discriminatory conditions or discriminatory practices or unfair practices. Like, for example, where you have limitations with regard to production or distribution, or restrictions with regard to production or distributions, or where you have prejudices that get created amongst the consumers, where you have practices which essentially directly amount to denial of market or market access. So these are called your various behaviors of abuse of dominance. And particularly where the markets have need deep pockets or need deep investments, they become even more apparent and more clear with regard to their practices being fair or unfair. So abuse of dominance is something that is at the heart of your entire Competition Act, particularly if you want to see with regard to the control of CCI with regard to the thresholds, the various thresholds that it puts in, the identification markers that it puts in, and why it brings in the controls that it has brought in is primarily because of this. So Competition Act, while it protects the whole market, it protects the customers, the consumers. It is at the same time, it also has to ensure that the market thrives. So the difference between Competition Commission and SEBI, as I'm fond of saying, is SEBI forgets that it is a regulator and behaves like a protector of investors. So it takes the investor protection to an extreme level, whereas Competition Act has the responsibility of ensuring that a thriving whole market is available to the consumers. So in its regulating the market, it has to keep in mind, while it is curbing the anti-consumer activities, it is not curbing the business practices itself. So you see, when we're talking about Competition Act, when we're talking about abuse of dominance, when we're talking about appreciable adverse impact, we are always talking it from the perspective of your mergers and acquisitions, from the perspective of the impact on the market. So it is this narrow area of impact on the market that the Competition Commission always tries to deal with. So with this, I'll come to the Eli Lilly case. Now, Eli Lilly case is a very, very interesting case because CCI had imposed a penalty of 10 million on Eli Lilly. Eli Lilly was a company which had acquired the Novartis animal health business. And while it did not notify this acquisition, primarily because it was under the understanding that the thresholds were not getting triggered. Now, why did it come into this understanding? It came into this understanding because the central government on 4th of March in 2011 had given a notification which exempted merger control obligations, where an enterprise that was being acquired and whose value and assets and turnover fell below a certain threshold. So they were sure that they were eligible for the de minimis exemption. CCI, on the other hand, was convinced that, well, you have contravened section 6.2, so you have to pay a penalty, and you simply cannot, just go around and say that we have acquired without giving a notification to CCI that you are in the process of acquiring. So of course, Lily goes to NCLT, and what does NCLT say? NCLT says that for the purpose of calculation of assets and turnover, what is relevant is the assets that is left over with the sellers after the acquisition will have little or no role to play in the context of business. So NCLAT essentially set aside this CCI's penalty. The reasoning of this, you can directly trace out to this: the Competition Commission's procedures in regard to the transaction of business relating to combinations. The regulations, they essentially go absolutely reverse to what the Act says. The Act says, that is under section 6.2, that the proposer has to give the notification. So anybody who proposes to take over a company X will have to essentially give the notification to CCI that we are taking over the company X. These are the valuations. Whereas the rules or the regulations say that the company being taken over will have to give the notification. So there is a complete clash. Now in this clash, if you read the central government notification, your Eli Lilly was perfectly in tune, saying that, well, we do not fall into the ambit for us to even inform. So this case was interesting primarily because it brought about, or it brought to the forefront, this clash in between the regulation, the provisions in the Act, and the central government notification. So with this, I come to the end of my presentation, and I'll be very happy to take questions with regard to what I presented today.
Thank you, madam. There are certain members who have raised their hands for queries.
Yes.
Rilvan, Mr. Rilvan.
Yes, sir.
Can you unmute and enable them to speak, Mr. Abdul Rashid and GR Hari, sir, one by one?
Okay, sir.
Yeah, please. Members, if you have any doubts, you can directly ask our expert.
Either you can ask through voice, or you can just put it in the chat.
Yeah, and the Q&A section, the Q&A option available, you can type in your questions.
Anybody who is not able to speak up could also put it in the chat box.
Yeah, absolutely. Alternatively, you can use our Q&A option available in the Zoom to type your query. Technical team, can you able to unmute the person who have raised their hand?
Yeah, I have had it, sir.
Yeah. Abdul Rashid, sir, are you there? You can unmute and speak, sir. Technical team, you can also add the other person who has raised his hand.
Okay, sir.
Mr. GR Hari, you can unmute them so that they can speak.
They have muted, sir.
Oh, they are muted, huh?
Yes.
Any queries from any of the delegates?
Sir, or alternatively, if there are questions later on, I'll share the slide with you.
Yeah, sure, ma'am, sure.
And maybe you could collect the questions, and I would be very happy to answer it. And I'm really apologetic about the quick ending of the session.
Oh, it's okay. It's okay. It's okay, ma'am. Okay.
Because
thank you very much, ma'am. Thank you very much for your valuable time and beautiful presentation.
thank you, sir. Thank you very much, sir.
Yeah, with that, we have come to the conclusion of today's program. Thank you one and all for your valuable presence and time. Thank you.
Thank you, sir.